Hello, and welcome to the National Archives Virtual Genealogy Fair 2014. My name is Diane Dimkoff, and I'm the Research Customer Support Coordinator. Our fair goes for 3 days, and we hope you'll be able to join us for all the sessions. A few quick notes before we start. If by chance during the Q&A sessions with our speakers you don't get your question read and answered, please send it in to inquire@nara.gov. It is INQUIRE at NARA.gov. You can also submit your questions, if you do so online, via Twitter using hashtag GenFair2014. We have a pretty tight schedule, so the speaker may not be able to get all your questions. So again, inquire@nara.gov. For captioning, go to the Virtual Genealogy Fair website and click on the link for today. These lectures are all being recorded, and they'll be posted on the Virtual Genealogy Fair webpage in November. If you're just joining us, this is session number 3. The lecture is entitled, When Saying I Do Meant Giving Up Your U.S. Citizenship, and our speaker is Meg Hacker. Did you know that from 1907 to 1922, American women lost their American citizenship by marrying non-Americans without even leaving the United States? Well, they did. And did these women regain their citizenship? Not necessarily. Meg Hacker is the director of the National Archives at Fort Worth, Texas, and I'm turning the microphone over to Meg.
Underused, incredibly interesting documents, and they have been, and I've been talking about them ever since. So sit back, relax, and I hope you enjoy this presentation. Nestled among the records from almost every federal court in America is a small body of records documenting women swearing allegiance to the United States. To be more accurate, re-swearing their allegiance. When the massive amount of naturalization records in the National Archives present similar information, people pledging loyalty to America, what is so special about this group? Well, these women in these records were all born in America. Some most likely never left this country, let alone their hometown, and yet they were swearing allegiance back to the United States. Why would these women not already be considered American? Since the earliest days of our nation, millions of people have gone through the process of becoming a U.S. citizen. Naturalization is a choice, not a requirement. And no rule mandates that one person must complete the naturalization process before it has been started, once it has been started. There is also no regulation promising the reinstatement of one's lost American citizenship. And there is always that pesky caveat that for a period of time, not everyone who loses their citizenship actually knew that they had lost it. The National Archives has partnered with Ancestry.com, Fold3.com, and FamilySearch.org over the years to digitize many of our holdings, including many naturalization records. At certain times in our country's history, marriage, at least for the woman, could affect one's citizenship status. If an American woman married a foreigner before 1907 and the married couple continued to live inside the United States, she did not, because of her marriage, cease to be an American citizen. According to the Supreme Court, no one could alter anyone's citizenship status arbitrarily. The individuals involved had to know that their citizenship status was being altered in some form or fashion. Just to emphasize this again, prior to 1907, the American woman remained a U.S. citizen even after her marriage to a non-U.S. citizen. But this is about to change. An act of March 2nd, 1907, also known as the Repatriation Act, changed all of this. Congress now mandated that any American woman who marries a foreigner shall take the nationality of her husband. Upon marriage, regardless of where the couple resided, the woman's legal identity morphed into her husband's. If a former American woman's alien husband became a naturalized U.S. citizen after the marriage, she would regain her citizenship through the very husband with whom she had lost it. If the same woman wanted her American citizenship restored and her husband had not naturalized, she had to go through the entire naturalization process as a true immigrant with all of its standard rules and regulations. Even then, she was still tethered to her husband through his political or legal standing. If the United States, for whatever reason, would not grant him citizenship, it would not extend any repatriation opportunities to his wife, whether she was born in America or not. This inequity in citizenship rights prompted Ohio Congressman John L. Cable to act. He sponsored legislation to give American women equal nationality and citizenship rights as men. The Cable Act, also known as the Married Women's Independent Nationality Act, or the Married Women's Act, passed on September 22, 1922, and it repealed the 1907 Repatriation Act. An American woman who married a non-U.S. citizen after September 22, 1922, would no longer lose her citizenship if her husband was eligible to become a citizen. The Cable Act was great news for couples marrying after September 22nd. But what about the women who had already lost their citizenship? What could they do? If they were already married by September 22nd, 1922, the citizenship had been impacted already. These women would still have to follow the full naturalization process. The Cable Act's restrictions caused some confusion. A woman's citizenship status no longer changed automatically upon the woman's naturalization. In fact, it did not change at all. Some women who had married before the passage of the Act understandably believed that they had either never lost their citizenship in the first place or assumed that they were the same status as their husbands, and no doubt children. After 1922, women who thought they had lost citizenship by marriage had to file a petition for naturalization if they wished to regain it. A woman's suitability for citizenship still depended upon her husband's status. He had to be eligible, whether he wanted to swear allegiance or not. The act did not affect expatriated women either, who had formally renounced their citizenship by personally appearing before a U.S. court. Nor did it affect women who had become naturalized under the laws of another country. In these cases, she remained a citizen of that other country. The changing laws could cause unexpected citizenship flip-flopping. Take a look at this petition. John Henry Pengelly arrived in New York in 1914 from England and started his naturalization process in 1916. According to his naturalization papers, he divorced his first wife in 1919 and married Bertha Anna Hack, born in Bayside, New York, sometime thereafter. Bertha Anna, upon this marriage, became a British subject. John Henry finally became naturalized in September 1923. But what was the status of Bertha Anna? Because of the Cable Act, she remained a British citizen who happened to be married to a newly naturalized American citizen. Somehow cognizant of the September 22nd Act of 1922, 2 years later, Bertha Anna naturalized on her own and regained her U.S. citizenship status. The residency issue was still a major thorn for citizenship. Contrary to the heart of the 1922 Act, there was another rule stipulating that if an American woman marries an alien and lives for 2 years in the country of her husband, or 5 continuous years anywhere outside of the United States, she is subjected to the presumptive loss of an American citizenship. While some people describe this quagmire as one of the greatest discriminations against an American woman, the Cable Act did permit that she could return to the United States to re-swear allegiance back to the United States. So there'd be no problem, right? Well, there was another hiccup in the vein of residency issues. While the Cable Act allowed a woman living abroad to return to the United States to regain her citizenship, a new law had been created that would cause some angst to the woman's journey back to America. Due to the 1924 immigration quota law, she would have to return as a quota immigrant. Regardless of what the Cable Act permitted, if the quota for her husband's country had been exhausted for that year, she could not get a visa, and therefore she could not return to the United States to repatriate. A few years later, another series of bills were passed affecting women's citizenship. Introduced in 1931, these resolutions actually removed the remaining inequalities of the 1922 Act, the ineligible spouse clause, and the foreign residency issues. Now, an American woman only lost her citizenship if she formally renounced it, naturalized under the laws of another country, taken an oath of allegiance to a foreign government, or if she had married an alien ineligible for American citizenship prior to March 3, 1931. According to one newspaper, our law for the first time now completely recognizes the dignity of an American woman's citizenship and permits her to feel her allegiance to our government is as fine, intimate, and sincere as a man's. 5 years later, an act of 1936 provided marital expatriates whose marriages to aliens had ended through divorce or death an opportunity to regain their citizenship by simply submitting an application. Upon approval, women could resume citizenship simply by taking an oath of allegiance. This act required the proof of the U.S. birth as well as proof that the marriage had ended. Women flocked to the courts to file their applications. The act, the 1936 Act, only allowed women to regain their citizenship if she took this oath of allegiance, provided her proof of birth, U.S. birth, and provided proof that her marriage had ended. Take a look at this oath of allegiance. Matta Gray Smith from Pleasant Grove, Iowa, married Englishman James Smith in 1919. James passed away on January 24, 1929, and she repatriated 10 years later. While the 1936 Act impacted the widowed and the divorced, what about those marriages that had not terminated? Well, Congress came to the rescue 4 years later and passed an Act of 1940 that addressed that very issue. The Act of July 2, 1940, provided that all women who lost citizenship by marriage could repatriate regardless of their marital status. They only had to take an oath of allegiance. No declaration of intention was required, but they still had to show that they had resided continuously in the United States since the date of their marriage. Here's an example of an application the woman had to sign. This is for Marie Annie Ackerman, born in New Orleans in 1888. She married Henry Carl Ackerman on December 13, 1905. Henry Ackerman was a subject of Great Britain. The form states, I lost or believe I lost U.S. citizenship solely by reason of such marriage. My marital status was such, alien has not been terminated, and I have never resided outside of the United States. Marie Ackerman takes the oath of allegiance in August of 1940. What is interesting about this is that she married in 1905, prior to the Expatriate Act. She probably did not have to file this. Here's another example of the repatriation oath. This is for Guadalupe Cuellar. She was born in Brownsville, Texas in 1907. She married Albino Campos of Matamoros, Mexico. They married in Bay City, Texas, August 7th, 1922, just a month before the Cable Act. With her marriage intact, she swears allegiance back to the United States in November 1941, and she also states that she continuously resided in the United States since her birth. What is amazing about these forms is that it gives you incredible detail not only about their physical appearance, but where they were from, what occupations they had. There's a tremendous amount of genealogical information right here. One of the oldest women we have found to repatriate is Susie Siegfried Stolzenbach. She was born in Austin, Texas in 1857. She married George C.W. Stolzenbach in 1912. George died in February 1942. When she repatriated in 1943, Susie was over 85 years old, having resided in the United States since her birth. These are really great records. Other countries had similar citizenship laws. Japan, for example, permitted non-Japanese women who married Japanese nationals to acquire Japanese citizenship. Similar to America, a former woman who acquired citizenship by marriage lost it upon divorce or repatriation. In this situation, Louisiana native Zeddy Isabella Stork Sudo lost her U.S. citizenship when she married William Sudo, a subject of Japan, less than 3 months before the Cable Act. She regains it in January 1942. One must wonder if December 7th had something to do with her decision to formally regain her citizenship. Here's a declaration of intention for a well-known Fort Worth citizen, Louis Joseph Laneri. The form shows macaroni maker Louis, who was born in 1888 in Genoa, Italy, married to a Fort Worth native named Mary. The declaration is filed in 1917. Everything looks just fine for Mary to get her citizenship restored. Here is his petition granting him citizenship, but it's dated November 15, 1922. So what happens to Mary? As we have discussed, had he received his citizenship on or before September 22nd that year, Mary would have been a citizen through Louis's naturalization. But because of the Cable Act, her status is independent to that of her husband's. So the story goes that Louis Laneri and his wife Mary married in 1910, lived in Fort Worth, Texas, their whole married lives. They own a macaroni factory called OB Macaroni, or Our Best Macaroni, still in existence. In 1941, they traveled together on a business trip to Mexico. Louis was let back into the United States, but officials wanted Mary's Italian passport and papers. Reportedly, this is the exact moment when she found out she had lost her naturalization, her American citizenship, 31 years prior. They quickly learned about the Repatriation Act and filed papers almost immediately. On March 22, 1941, Mary Laneri has her American citizenship restored. Here's one of the most recent oaths we have located to date. Bernardina Tobias, born in Richwood, Texas. She married Fortunato Castillo in Monterrey, Mexico. Her husband passed away in 1976, and Bernardina repatriated 5 years later, in 1981. I really wish I could have interviewed her and asked her, how did she find out? Did she know? What were all the details in finding out about her repatriation and how she felt about it? So how do you find these records? Since women could repatriate at any court, county, state, or federal, the records could be anywhere. Some of the federal court records have been digitized and are available on the National Archives partner sites Ancestry.com, Fold3.com, and FamilySearch.org. While some federal courts provided indexes to these records, others did not. Some of the archival facilities, such as the National Archives at Fort Worth and the National Archives at Riverside, created in-house indexes to these repatriation oaths. Here is a snapshot of Fort Worth. This index provides the wife's name, her date of birth, the husband's name, his nationality, and the court information necessary to locate the oath. As mentioned before, many of our records are being digitized and will be available online, but to date, not all of these records that you see on this page in particular have been digitized. A PhD candidate in California was a little more creative with his statistical analysis of repatriation oaths. They also created an index. Note the titles: years of marriages ending in divorce, years between termination of marriage and oath, where they were from, the state of the marriage, what was the percent of the people in their files that were married in that state, and many other analysis. You can contact the National Archives at Riverside for more information about this PhD's candidates' statistical analysis of their repatriation oaths. So where are they from? The assumption people make is that they're going to be just from Canada or Mexico, our border countries. But as you can see, this list shows a wide array of nationalities of those women seeking repatriation over the years. It is amazing to see the different countries, Argentina to Yugoslavia, and all countries in between. And these, frankly, are the ones that we found just in our records located at the National Archives in Fort Worth. The original repatriation oaths are housed at the National Archives locations across the country, coast to coast, border to border. So for contact information, please go to our main webpage at www.archives.gov and click on the orange section entitled Our Locations. The courts often kept the repatriation oath separate from other naturalization records. And when they did, the series titles usually include the word repatriation. Most facilities have the oaths, but not all facilities will have cases, case records, certificates, or proceedings. For instance, the National Archives at Fort Worth only has the actual oaths. Here is a random oath I located on Ancestry.com. Amelia Abraham from Alexandria, Louisiana, married Mark Abraham in 1903. Technically, again, she should not have taken the oath because she married before the 1907 Act. You never quite know how the laws will be interpreted or applied. Once all the repatriation oaths are digitized and uploaded onto our partner sites, searching for these women should become much easier. Until then, keep in mind that the federal courts across the nation maintained repatriation oaths in different ways. Some kept them separately with an index, some kept them separately without an index, Some combined the repatriation oaths with all of the naturalization records with an index, or they combined them without an index. The next three images are those from a repatriation case file out of the National Archives at Riverside. Here you will see the marriage certificate for John Joseph Whalen, who married Laura J. Carnegie on February 28, 1912, in Redwood City, California. The other document in the repatriation case file was the death certificate of the husband, John J. Whalen, and he died in 1935. And the last piece of paper in the case file is the repatriation oath for his widow, Laura Jane Whalen. She repatriated February 1st, 1939. In addition to losing your citizenship upon marriage from 1907 to 1922, there were other ways to have lost your citizenship in the 20th century. Let me briefly go over a couple of these. Americans also lost citizenship when they voted in another country. Here we have the repatriation oath for Seattle native Kiyo Tsukamoto. She voted on April 1946 in Yokohama, Japan. In order to regain her American citizenship, she swears that she did not partake in any cause of communism, nor had she committed any other act that would expatriate her. Many men unknowingly lost their citizenship when they enlisted in the Canadian and British forces prior to the U.S. entry into World War I. A 1906 act allowed for the repatriation of U.S. men who had served in the armed forces of another country at war with a country with which the United States is now at war. So American men who expatriated themselves by swearing allegiance to another nation during World War I had it slightly easier. They only had to file an oath of allegiance to restore their U.S. citizenship. Here we have the repatriation oath for Hugh Guernsey, who had joined the Canadian military in 1916 and applies for repatriation in 1939. Here's another example of military repatriation. This one is for Joseph Adam Kramer, who joined the military of Canada in 1915. He repatriated in December 1940. American-born women are also affected by the military rules. Here we have a rare one for Mildred D. Whitten, who served in the British military in 1943. She repatriated 3 years later in 1946. There are so many juicy caveats in American history that makes genealogical research a never-ending mission. If you believe your ancestor repatriated and you cannot locate her on our online partner sites, contact the National Archives Research Facility responsible for the state in which your ancestor resided. The best place to start a for repatriation records is online. Several series of records have been digitized and can be found in the National Archives Online Public Access Catalog, OPA, and on our partners' website, Ancestry.com, Fold3.com, and FamilySearch.org. Keep in mind that the different sites will have different sets of records. On Ancestry, you'll select the search category Immigration and Travel. On Fold3, you'll select non-military collections and then naturalization petitions. On Family Search, you can choose a filter by collection after you typed in the person's name and dates. All of these online sources continually add material, so it helps to check back regularly. Check out our spring issue of Prologue for my whole article on repatriation oaths in the Genealogy Notes section of the magazine. As always, it has been a pleasure speaking to you on repatriation oaths. Perhaps I've piqued your interest into researching these records to see if any of your family members might have sworn an oath or two. If you have any questions, please do not hesitate to send them to inquire@nara.gov. I welcome your questions, and I look forward to hearing about your repatriation finds. Thank you.
Thank you, Meg. We've received a lot of questions for you from YouTube and Twitter. So the first one comes in from Twitter, and it is, were Italian women under particular pressure in 1941 and early World War II to swear allegiance to regain citizenship?
That's a good question. In terms of Italian citizenship, I have to say they are probably our most popular repatriation in there, as well as our naturalization. I can't speak to the emphasis that they may be giving women, but I can say that there are a tremendous amount of naturalized records pertaining to Italian subjects right now, dating from that time period.
Thank you. The next question is from YouTube. So this loss of citizenship only happened to women, not to American men who married foreign women? Get the outrage?
Yes, that is quite true. And it's interesting to see that in England and France and many other countries, they followed the exact same philosophy as the Americans did. Whatever the husband was, the wife was as well. So if a British man marries an American woman, his wife is now deemed as a British subject.
Thank you. Next question from YouTube. Would the loss of citizenship by a woman affect lineage society applications? And how would an ancestor find the info?
Oh, that's a great question for which I have no clue how that's going to impact the lineage one. Half the time, many of the women just truly didn't know they lost their citizenship. And it is an arbitrary law that America and other countries have established. So the bloodline, the true ethnicity of it, should be intact. But I would check with that society or just don't mention it at all.
Thank you. Next question from YouTube. Since this did not apply to men, what was the reasoning behind the 1907 Act?
My understanding is that it was a time in American history that we really wanted to know who everybody was. We wanted to make sure that the women had their their nationality and their citizenship and all their other rights, as few as they were, in line with their husband. What he was, they were. And it was just a way, I think, of controlling what was out there. That's my personal opinion.
Thank you. Next question from YouTube. Is there a list somewhere, city, county, state, federal, of these women?
I can't speak for all of the ones, especially for the county and the state. It's best to contact them. For the ones that are in the National Archives, I know for a fact that Riverside and Fort Worth created in-house finding aids that will identify the women by name. Also, you might check with Ancestry, Fold3, and Family Search to see what kind of indexes they have created after they have digitized their naturalization records.
Thank you. Next question from YouTube. What is the definition of an ineligible alien?
It's a very good question. Ineligible could be a wide variety of reasons. Perhaps they were communists. That was a big no-no at the time. Perhaps they had committed some offenses that the government deemed that they were not worthy to be an American citizen. There could be something that came from their homeland. So I think it's a very open-ended question, but it would make for some really good genealogical stories around the table.
Thank you. Next YouTube question. Is there a place we can find digitized naturalization records, not just for these women, but for all immigrants? I want to check my family's marriages that fall within this date range.
Ancestry.com, fold3.com, and FamilySearch.org are excellent places to start looking for them online. By no means are they complete, but they would be a great place to start with. And then after that, if you still can't find them, contact the National Archives facility that is responsible for the state in which they lived. And again, our list of locations is online at www.archives.gov, and just click on the Our Locations tab, and we should be able to go from there.
Next question from YouTube. How do I find someone's oath of allegiance? Is it indexed anywhere or included in naturalization listings?
For the oath of allegiance, they are usually kept separate at least in Fort Worth and I believe in Riverside as well. They are kept separate in separate series. Others courts might have mingled the records in with the regular naturalization records. So again, I think I would start with the court in which you think that they might have repatriated, contact that archives location and see if they can't help you narrow it down. But one of the easiest things might be just to start with the Ancestry and Fold3 and Family Search, and then when you can't find them there, then I think I would contact the archives.
Thank you. Again from YouTube, would the children also lose citizenship?
Very good question. I think in terms of the children, they were usually whatever their parents were, and now that their parents, one might be one might be the other, they tend to be in a matriarchal fashion. They are what their family is. But I am by no means an expert on naturalization. I think I would check with the laws at the time that the person was naturalized.
Thank you. And our last question from YouTube. Did the other countries view these women as their citizens?
Excellent question, and one of my very favorite, and I'm so glad you asked that, because that was my premise back in the mid-'80s when I first started to research these records. Surely there was a country out there that didn't recognize them. And the more I researched, the more I realized I really needed to have taken French as a language instead of Spanish in college. So the UN had a huge amount of articles on women's citizenship and who recognized who at the time. And frankly, I'm going to have to let you find out the answer because I couldn't read the articles that were written in French that I just knew answered that very question.
Meg, I guess I lied. We have another question from YouTube.
Oh, no.
How do you find
Okay.
declaration of intent papers?
Declarations of intent are part of the naturalization process. They are usually the very first papers. Sometimes they're even called first papers. So they should be part of the naturalization documents held at the state, the local, and the federal courts. So the process would be very similar. Just go to, you could start with Ancestry, Fold3, and Family Search. You can also contact the National Archives and seek information about the court in which your ancestor might have filed those papers. Everybody has different age, date ranges. We have different, some cases might be online, others might be indexed. It's best just to contact and ask us.
Thank you. And it looks like we have another one. Did a woman lose her citizenship when her American husband worked and died in Mexico?
Well, that would depend on if the husband was, you said as an American citizen dying in Mexico, is that right?
Yes. Did a woman lose her citizenship when her American husband worked and died in Mexico?
It shouldn't have had any impact, but there are always caveats to American history, which makes us a very interesting country. So my knee-jerk reaction would say no, it would have no impact. But there's an asterisk to it. So I would check to see if there was something else that's happening at that time.
Okay, now I really think that is the limit of questions. Thank you, Meg.
Okay.
Again, if the speaker did not get to your question, please send an email to inquire@nara.gov, and we'll now have a short intermission and we'll resume broadcasting at 1 o'clock. That session will be Overview of American Indian Records and Resources on the National Archives website. Thanks again, Meg.
Thanks. Bye-bye.